We begin with those new developments tonight. It could be curtains for Congressman Doug Lamborn, the Republican who's been elected 6 times to represent Colorado Springs and our surrounding area in Washington, will not appear on the June Republican primary ballot, a ruling handed down today by the Colorado Supreme Court. News 5's Zach Thaxton has been tracking this situation for the past month. He's in studio tonight to explain in tonight's top story. Zach?
Well, this all stems from 5 Republican voters in the Colorado Springs area who had suspicions about petition circulators hired by Congressman Lamborn and whether they actually lived in Colorado. Well, the state Supreme Court today ruled that one of them does not, leaving Lamborn short on signatures and off the ballot in his own re-election bid.
We quickly discovered what looked like obvious patterns of fraud and people that were illegally circulating from out of state.
Victory for the attorney representing plaintiffs who sued to derail Doug Lamborn's bid for a 7th term in Congress. The state Supreme Court overruling a lower court's ruling on Monday, saying a petition circulator who gathered 269 signatures is not a legal Colorado resident, invalidating every one of those signatures. Lamborn needed 1,000 to make the primary ballot. This leaves him well short.
I'm glad that the Colorado Supreme Court decided to follow the law, and I think it's a victory for election integrity.
The suit alleged petitioners hired by Lamborn's campaign lived permanently in places like Michigan and California, and all piled into one house in Thornton, registering to vote in Colorado just days before starting to collect signatures, not establishing permanent residency as required by law. Under Colorado election law, out-of-state petitioners can collect signatures for ballot issues, but not for candidates for office.
We think it's an affirmation of Colorado's election system, but also a good signal for people that are doing petition circulating that you need to follow the rules and not hire people from out of state, which is a violation of the law.
Lamborn's campaign says it will appeal to the federal level to try to stay on the ballot. Meanwhile, his would-be opponents are offering praise and support.
He's done a lot for this community. I don't know whether this is the end or not, but I think it's important to respect what he's done. And again, I'm personally going to pray for him.
He's had almost 3 decades in office, and so I appreciate that. That takes a toll, but it requires a lot of faithfulness. Appreciate his faithfulness on that front.
Fellow opponent, retired Judge Bill Ray, adding, even though it would likely help me in this election for Lamborn to be pushed off the ballot, I do not favor that result. Now, Lamborn needed to petition his way onto the ballot after skipping the county assembly process. He was first elected to represent the 5th District back in 2006. The Republican congressional primary is June 26th. Always watching out for you. Zach Thaxton, News 5.
Zach, thanks. And the Secretary of State's office says that it's too late for Lamborn to run as a write-in candidate for the primary, but he can run as a write-in in the general election. Also, the Supreme Court did not address the constitutionality of the residency requirements, only that existing law invalidates those signatures, as you heard from Zach, collected by people who do not live here. The residency issue may be Lamborn's next play at the federal level, and there is precedent that could work in Lamborn's favor. In fact, the Deputy Secretary of State said today this decision paves the way for the federal court to strike down residency requirements, as it already has for non-residents who have gathered signatures for ballot initiatives. Now, we're awaiting word from the Lamborn camp on their next move. We'll continue to track this story for you.